Is there such a thing as an amicable divorce?
Well, I like to think.
Welcome to the Sinclair Law podcast, where we delve into the intricate world of family law. I'm your host, Sandra Sinclair, and in this episode I'm joined by my colleague, Lucy Hart.
If somebody's had an affair with their secretary, then they think, well, he's done that.
But he should be punished, shouldn't he? Or she should be punished.
Well, I mean...
Today, we tackle some of the most frequently asked questions in family law to provide you with some expert insights and valuable information to navigate the complexities of family legal matters. So, Lucy, shall we start by chatting about family law and trying to put some definition on what it actually is and what it means for people?
Yeah, so family law are legal issues that a family might encounter to do with their relationships. So we become involved either at the beginning of a relationship where unmarried couples are moving in together and want to regulate their financial arrangements, or a prenuptial agreement when people are getting married and want to secure their future in that way, or it could be at the end of a relationship when people are getting divorced and want to look at financial settlements, any disputes over the arrangements for children, where they're going to live, what school they're going to go to, that sort of thing. So it's the legal issues surrounding relationships, essentially.
So it's interesting that you've mentioned prenuptial agreements, because one of the questions that I get asked frequently is they're not really worth the paper they're written on. What's your view?
Prenuptial agreements, that's a difficult one because they are complicated things. And I think the first thing to say is that a prenuptial agreement can never be 100% binding. They're great for people who want to regulate their finances in case of a divorce if they're getting married. There are key things that need to be included in a prenuptial agreement to give it the best possible chance of being binding if a divorce does happen. There's various things. You have to both seek independent legal advice to make sure that, nobody's under undue pressure or feels that they have to sign it or the wedding's not going to go ahead.
Mm-hmm.
Both people need to be fully aware of the other one's financial circumstances. It needs to be done a set period of time before the wedding. You can't be signing it before the moment before you walk down the aisle.
Because some might think that you've been put pressure upon you to do that.
Exactly, yeah. So, it all has to be done in good time, properly considered. And the main thing is it does still need to be fair. I mean, I think there's a bit of a myth about prenups that, if you have one person who's very wealthy, then a prenup can be used to completely exclude the other person from ever receiving a share of that wealth.
And that would not be regarded as fair, would it?
No, it wouldn't, no, because the law is very clear that after a marriage, then the needs of the parties need to be met. And if a prenup doesn't do that, then, it can be overturned. So they're not 100% legally binding, but they certainly, I would say, are worth the paper they're written on if they're done properly.
And I suppose it would particularly benefit those who've already been through a traumatic separation and financial outcome previously, and they're going into marriage for the second time around. Would you say that's when people come and ask for advice on a prenuptial to avoid the pitfalls of them having experienced that previously?
Absolutely. I would say the vast majority of people who come to us for prenups are second marriages where they've had a very messy divorce and they don't want to go through that again, or they've got adult children and they've discussed it with them and decided that it's a good idea for the family as a whole. It does tend to be people who are a bit more realistic about what might happen with a marriage.
Once bitten, twice shy.
Absolutely,
yeah.
Absolutely.
People can and have had a messy divorce. Is there such a thing as an amicable divorce?
Well, I like to think there is, Sandra. I mean, although divorce is never a nice experience. Nobody can ever say it's going to be the best thing that ever happened to them. It's a difficult time. We certainly like to think that there are ways that you can keep things as amicable as possible, because at the end of the day, particularly if you've got children, you are going to remain connected and you want to still be parents together and everything else.
The cynics amongst us, though, would say it's better for the lawyer if there's a messy divorce because there's more fees.
Unfortunately, a lot of lawyers, I think, do approach it in that way, which probably gives us a bit of a bad reputation. But, I mean, that's not the way that I work, and nobody at our firm works that way. If two people come to us and they have a possibility of being amicable and having an amicable divorce, we will do everything we can to maintain that. And there's various ways that you can get divorced. To talk about your financial settlement, you can go to mediation. And that's
And what does that look like? I mean, can Sinclair Law offer a mediation service?
So mediation is an independent person. An ideal situation with mediation is that you each have your own lawyers, so you have legal advice from your solicitor, but the mediator is an independent person. So when you are talking to that mediator, they're not on anyone's side. You sit down with your partner, with the mediator, and have a constructive discussion about what is going to be best for the family moving forward and how the finances can be divided in a way that's going to make sure that everybody can move on with their lives. And then after that meeting, you come and get the advice from your solicitor in the background, but that can be a good way of keeping things amicable.
So I guess what you're saying is that you can figure it out between you with the assistance of an independent mediator, and then take separate legal advice once you've reached the point where you think there's an outcome that can be achieved.
Absolutely, yeah. And, the solicitor can still be involved throughout the process because, the agreement still needs to be something that's legally possible, and that is an agreement that is going to be approved by the court at the end of the day. So it still needs to be within that realm of fairness. But there are, many ways that you can keep things amicable. Even if you don't feel comfortable going to mediation and your solicitor is negotiating a financial settlement for you, again, that doesn't necessarily mean that everything becomes acrimonious and everyone's fighting over anything. It's just a way of keeping things at arm's length and having that sort of separation from it.
Because I've heard recently that the courts are very keen to encourage parties who are going through separation and divorce always to try an alternative way of resolving their disputes. So is it now becoming more compulsory, do you think?
Firstly, before you can make a court application for the court to look at your finances for you, which we would consider to be, a last resort effectively if you're not able to reach agreement, you have to show to the court that you've attempted mediation in some way, or that alternative means of reaching a settlement are entirely inappropriate. For example, if there's, domestic abuse situation or something like that. And the court are really considering other alternative means of dispute resolution as well. So private means of resolving disputes like arbitration or private dispute resolution hearings, because the court is so overwhelmed with the amount of work that they've got that they are really trying to push looking at alternative means. And, a solicitor should be advising people on what those alternative means are.
A good family lawyer would do that, wouldn't they?
Absolutely, yeah. I mean, you have to look at all the options. I certainly find a lot of people come to me and say, oh, it's so straightforward, it's really amicable, this will only take you, a few hours, it'll be really easy. And they're often the ones that are actually very complicated and potentially become more acrimonious because they're sort of not really considering what it all means. So it becomes more complex than what they originally thought, and that can cause a lot of tension.
So what would you say the ethos of Sinclair Law is with regard to alternative dispute resolution?
I would always encourage it where it's appropriate. And I would always encourage it in a way that's alongside having proper advice. Yeah. I would never say to somebody, just go off and sort it out yourself over the kitchen table and just tell me what you come up with. We need to support people who are going through that difficult process. Equally, if you've got somebody on the other end of the spectrum who is vulnerable, in a very difficult position.
Because those are the people I would be thinking of. The person who is persuaded to go to an alternative dispute resolution meeting and perhaps may not get the outcome that suits them or is right for them, but they've been cajoled into that route, which may not be good.
Well, I think one of the skills of a good family lawyer is recognising somebody like that and protecting them from that happening. And if you do have a client who's in that position, you need to make sure that doesn't happen. And it could be that the other person isn't willing to provide full details of their financial circumstances.
You mean they're trying to hide things?
Exactly, especially if they're trying to sort of squirrel away money and to hide things and to try and make out that they've not got anything, just to try and stop the other person from receiving a share.
And I suppose a good family mediator would recognise that as well and make sure that that person is directed back to their legal advisor.
Yeah, I mean, part of the mediation process is full disclosure of your finances. So again, if the mediator has any doubts about those things, then they need to direct the client back to the solicitor. And sometimes a court application is necessary, and that is the best way of helping somebody to make sure that they get a fair deal, because I think that's what we're all about. We need to make sure that our clients get a fair deal, they get an excellent service from us in a cost-effective way, and we don't push them down a route that we think is right for us. We advise them on the routes that we think are right for them based on their personal circumstances.
So in conclusion then, a good family lawyer will find solutions rather than a bad family lawyer who will take a client to court at the first opportunity.
Absolutely. It's about finding solutions, not creating problems.
When we're thinking and advising clients in relation to financial outcomes, we also have to consider the children, obviously, in any financial settlement. In what way do you think that impacts upon a financial outcome where there are young children or teenage children involved in that? For example, I had a case recently where the mum said to me, well, we're divorced now, I can't afford to live in the house. I'm going to have to move somewhere else to be closer to my family, my mum and my dad, my sister, my brother, who can help me support looking after the children. What kind of position are you likely to take when faced with that?
Divorce is never an easy thing, and particularly when children are involved, whatever age they are. I mean, I've got cases where there's adult children and that is a major factor. They're still living at home, they're still supported by their parents, even though they're in their late 20s, early 30s. So the children issue is something that does make things very difficult and challenging to deal with. One of the main things is meeting the needs of the parties and, the housing needs of the children. But there is that practical thing when you don't live with your partner anymore, you're becoming a single parent, and, the children might see the other person, you might have equal shared care, but that does mean that there's a significant portion of the time, day to day, where you are a single parent.
Because mum might say, well, I cannot go out to work full time because I need to look after my young children. So I'm going to move to this part of the world. It's either abroad or in this country. And what advice would you give to a client who came to you and said, I've already made plans and I'm off, I'm taking the children with me?
Well, the easy answer to that is you can't do that, because when parents separate, whoever the children are living with or spending most of their time with, both parents still have equal what we call parental responsibility. And that means that there are certain decisions that have to be made by both parents together. Big decisions like where the child lives, what school they go to, religion, medical treatment, that sort of thing, they're still always going to have to be joint decisions. So if somebody comes to me and says, I need to go, I'm going to move and be where my family is, which does happen, that's quite a common thing, my advice has to be to them, you need the other person's consent to do that. And if the other person doesn't agree, that is a situation where the only alternative is a court application. And it's actually quite common that there is no agreement over that because, obviously the person who's remaining doesn't want the children to move 100, 200, 2,000 miles away to where that person wants to go to. they obviously want to maintain a close relationship with the children.
So what happens then in that situation where the client ignores your advice and goes anyway?
Well, that then results in an urgent court application to get the children back.
And is that likely to happen?
Yes, that would be likely to happen in those circumstances. I had a case a couple of years ago where the mum did do that and took the children, and we made an urgent court application for them to come back. So the children then came back and lived with their dad. And by the time the court application had been resolved as a whole, the children, because of the length of time of the proceedings, the children had been living with their dad for like 9 months by that point, and the court then found it almost impossible to move them again because they'd become established with their dad.
So in that situation, it really went against the mother's interests.
Absolutely, she
in
shot
having
herself
the
in
children
the foot.
with her, because ultimately she lost out to that application.
Absolutely, yeah. So it's never a good idea to just run, because it can go horribly wrong, and it needs to be a considered decision, and often it does involve the court because it's such a black and white yes or no. There's no compromise. There's no
grey area.
There's no real way of meeting in the middle, because if somebody wants to move 200 miles away, it doesn't help either party to say, oh, we'll just move 100 miles away, because then nobody's happy with that. There's nothing in the middle. So, but I think the key to that is you need to take proper advice as soon as possible, because people want to move for a variety of reasons, to get help with childcare, with family, or they want to time it with starting a new school in September, and you need to understand that this process takes some time. So, if you are thinking of moving and you want to be there set up for September to start a new school, you really need to be taking that advice months and months beforehand to allow the opportunity for all of the factors to be properly considered.
Okay. And taking that to its extreme then, if one of the parents moved out of the country and re-established themselves elsewhere, somewhere else in the world, what view would the court take in that event?
Well, the principles are the same, really, in that, you can't take the children anywhere else where the other person doesn't agree to live, whether it's 300 miles away or 3,000 miles away. Obviously, if they've gone to another country, it's practically more difficult.
And tantamount to child abduction.
Well, it is child abduction. And a lot of parents say, well, I can't abduct my own child, but that is child abduction and, really should not be happening.
Let's talk about affairs.
The juicy stuff.
Yeah, and I think there's a common misconception about if there is an affair, if someone's having an affair in the marriage or in a relationship, that's going to have a consequence. What is the actual position with regard to that?
That is a common misconception. I can't tell you the amount of times I've met with a client for the first time and they've told me that their husband or wife has had an affair, and therefore that must mean that they can keep the house, for example. If somebody's had an affair with their secretary, then they think, well, he's done that.
But he should be punished, shouldn't he? Or she should be punished.
Well, I mean, maybe, but that's not for us to decide. The reality is that the reason why a marriage is broken down, whatever that might be, is not going to have an impact on the financial settlement. It may be that the person does stay in the house, but it won't be because the other person had an affair. And I think that is actually a really difficult thing to discuss with the client in a first meeting when they've got that preconception. And
particularly when emotions are running high.
Yes. Yeah. I mean, it takes a lot for somebody to come to a first meeting. They're often very emotional. To explain that to them, that that's not going to have an impact is hard, because people do expect that it should. And people do feel obviously very wronged by the situation, and it's difficult to comprehend, well, why should he get the same as me when he's done that, or why should she, in the other way around. What we call conduct in financial proceedings is actually very rare that it makes a difference, and having an affair is nowhere near the benchmark where any type of conduct would be taken into account. So yeah, that is a common misconception, and it is a difficult one for people to get their head round, really.
Someone tells me that you're coming up to having practiced in the law for 20 years.
Gosh, that makes me feel a bit old, really.
Well, you don't look old, may I say. But there must have been some highs, obviously some lows. What are the highs? Let's talk about that.
Honestly, there's been so many, and if I had my time again, I wouldn't change a thing, because I do love this job. And I think just being able to be in a position where, I mean, we've talked about a lot of difficult topics, but at the end of the day, doing this job, you do have the opportunity to really help people when they're in what can be a very difficult situation. And at the end of the case, you know, people are put on a new track in their lives, and you know, there's something really satisfying about that you've got them to that place. You know,
there's always that light, isn't there?
There's always
at the
a light.
end of the tunnel. There's
absolutely.
always a light.
And at the end of the case, or even if it's been a really difficult, long drawn out, complex matter, that light is always there. And I think enabling people to see that and move towards it is really, really rewarding. That's my highlight, and that happens again and again. So you never get bored of it. You meet different people all the time. It's such a people-focused job. You know, people have this image of being a lawyer in a wig, you know, covered in dust, sat behind a desk with big fat books in front of you. But, you know, that's not what our job is. You know, there's obviously the technical elements of the law that we deal with, but essentially you're dealing with people's lives and meeting such a wide range of people, and every case is different. And I can't think of another job where you would get that. And, you know, we work with great people as well. You know, we have a brilliant crowd in the office, and, you know, it is a difficult job. So, you know, you do need to have good people around you, you know, to bring you up when you're having a difficult time and to support you. And I think we've really got that. So, and I think that's one of the things that I'm really proud of in our firm, that we have the great people who are there, excellent lawyers, and really good people who really care about the clients as well.
So in summary, challenging but very rewarding.
Absolutely.
A couple of more things before we wind this up. Why should a client come to Sinclair Law?
The different thing about our firm is we are all experts in our field. There's no question about that. But we are also approachable and really look to find solutions and not create problems at a price that people can afford. So I think that is the reason why we're different.
Agreed. Thank you. So, in closing then, our very first podcast for Sinclair Law.
Yep.
Hope you've enjoyed it. I've loved every minute. Let's do it again soon.
Absolutely.
Thanks, Lucy.
Thanks, Sandra.